Hello, I am Major Mark Lampton, a trial defense attorney with the 972nd Trial Defense Team of the Mississippi Army National Guard. It is my responsibility to discuss your rights under the Mississippi Code of Military Justice. This video is designed to help you understand the Article 5 being offered to you by your chain of command. You should watch this video before you speak with an attorney about your specific case. You should have already been provided a copy of the Article 5 with supporting evidence, and a first reading should have already been completed by your commander or a senior non-commissioned officer. Your commander suspects you have committed a violation of the punitive articles of the Mississippi Code of Military Justice, or MCMJ. He or she had the option of preferring court-martial charges against you or offering you non-judicial punishment under the provisions of Article 5 of the MCMJ. Your commander opted to offer you non-judicial punishment. Please open your packet and the actual Article 5, which is Form AGO 202. Please note that your commander may be using a DA Form 2627, which is the active duty version of the non-judicial punishment form. If the active duty version is used, your command should have marked through references to the Uniform Code of Military Justice, or UCMJ, and replaced it with the applicable reference to the MCMJ, which is the proper code for use in an Article 5. Regardless of which form is used, you are entitled to the same due process rights of notice and a right to be heard. When the requirements of both forms are the same, I will refer to the form simply as the Article 5 charge sheet. Has your commander signed page 1 of the Article 5 charge sheet? Did your commander conduct a first reading of the charges with you prior to your viewing this video today? If the answer to either question is no, please ask your supervisor to ask your commander to contact their unit judge advocate for instructions, or contact Trial Defense Services personnel after this video is completed. Please take a moment to examine the other documents in the packet. Those documents will include the signed Article 5 charge sheet and copies of the documentary evidence that support the charge or charges in the Article 5. The packet should also include a DA Form 268 or a report to suspend favorable personnel action and a copy of your enlisted record brief or officer record brief. Anyone receiving an Article 5 has the right to turn down the Article 5 and request trial by courts-martial. The decision of whether to accept the Article 5 or request trials by court-martials is an important one. Let us examine the differences between the Article 5 and court-martial proceedings in order for you to make an informed choice. Article 5s are more informal than courts-martial. This informality means that while you have the right to speak with an attorney, you're not entitled to have a lawyer present at your hearing. A soldier receiving an Article 5 will not have, as a result of an Article 5, a criminal conviction. The result of the Article 5 will not follow you to your civilian life. The imposing commander decides whether you are guilty of an offense, and that person will also decide what the punishment will be. However, you are granted the right to present matters in defense, mitigation, or extenuation. Matters in defense are those matters that would lead your commander to conclude that you are not guilty of the crimes for which you have been charged. You should note that even in an Article 5, your commander must find that you are guilty of the charged offense beyond a reasonable doubt. Matters of mitigation are those matters that would explain what occurred in a way that makes your conduct seem less blameworthy. Matters in extenuation are those matters about yourself that will help your commander see that certain punishments are not appropriate in your case. Please remember, your constitutional right against self-incrimination means that you don't have to provide any statements or any evidence if you don't want to. You may appeal an Article 5 after it is completed for any reason. Finally, you have the right to turn this informal measure down and request trials by court-martial. Court-martials are formal disciplinary proceedings. You are usually represented by counsel as the government and a military judge presiding over the whole proceeding using the rules for courts-martial and the military rules of evidence. If found guilty, the record of those proceedings by itself may provide the basis for keeping you from exercising basic rights as a citizen. For example, owning a firearm or voting. No one can tell you exactly what will happen should you decide to turn down this Article 5 and request a trial by courts-martial. Your commander may decide to take no action. He may handle it with some administrative procedures like a bar to reenlistment or administrative separation, or give you what you asked for in a trial by courts-martial. If you request a trial by courts-martial, the Article 5 process will be delayed until the commander decides whether to prefer court-martial charges or to forward the request to the next higher commander and wait for higher command's determination whether to grant the request for court-martial. The reviewing higher commander may also deny the request for courts-martial and allow the subordinate commander to proceed with the Article 5. If the superior commander refers the charges back to the lower commander with authority to proceed with the Article 5, then the commander may proceed with the Article 5 despite your request for courts-martial and without your consent. If you are granted courts-martial, the courts-martial process is designed to work quickly but may still take months. Keep in mind the suspension of favorable personnel action, or FLAG, will likely stay on your record until the command has disposed of this matter, either administratively or through the courts-martial process. You should also know that the command may add more charges if your demand by courts-martial or for trial by courts-martial is granted. Please remember that accepting an Article 5 does not mean you are pleading guilty. It only means that you accept that the commander is seeking to impose punishment and will determine if you are guilty or are not guilty. If found guilty, then the commander decides an appropriate punishment. Let's look at the potential punishments one might receive at an Article 5. First, an admonition or reprimand may be imposed. These are two forms of censure intended to formally criticize a person's conduct. A reprimand is a more severe form of censure than admonition. A reprimand or admonition received in conjunction with an Article 5 is considered punitive. Admonition given to commissioned or warrant officers must be in writing. Admonitions given to an enlisted personnel, regardless of their rank, may be oral or in writing. Second, a restriction may be imposed. Restriction is an order that confines a soldier to a certain specified area, such as a military installation or certain areas within a military installation. This is the least severe form of deprivation of liberty. Company grade officers in command can impose 30 days restriction, and field grade officers in command may impose 60 days restriction. Third, a soldier may be assigned extra duties. These duties are in addition to whatever duties a soldier is expected to perform during a routine workday. Military duties of any kind may be assigned as extra duties. Extra duties assigned as punishment of a non-commissioned officer should not be of a kind that demeans their grade or position. Company grade officers in command can impose 14 days of extra duties, and field grade officers in command can impose 45 days of extra duties. If your commander imposes extra duties, he or she may only require 2 hours of extra duties for each day that the extra duties are imposed. Fourth, an imposing commander may reduce a soldier receiving Article 5 in rank. Company grade officers in command can reduce a specialist or below 1 grade. They cannot reduce a sergeant or above. Field grade officers in command may reduce a specialist or below to private and may reduce a sergeant or above by up to 2 pay grades. The authority of individual commanders to reduce a soldier with an Article 5 will vary according to the rank of the officer and the nature of the command. If you have any questions about the reduction authority of the commander imposing this Article 5, please exercise your right and request to speak with a trial defense attorney. Fifth, a commander imposing punishment under the provisions of Article 5 may direct forfeitures of pay. Forfeiture means a permanent loss of entitlement to pay is forfeited. The only pay subject to forfeitures are basic pay, C-pay, and hardship pay. Forfeitures may be taken from no other form of pay, such as special qualification pay or hazardous duty pay. Please note that if a punishment includes both a reduction and forfeitures, the forfeitures are calculated at the reduced pay grade. Company grade officers in command may cause a soldier to forfeit 14 days' pay. Field grade officers in command may cause a soldier to forfeit 1/2 of 1 month's pay per month for 3 months. Sixth, a commander may impose a fine as part of the Article 5 process. A company grade commander may impose a fine of up to $10. A field grade commander may impose a fine of up to $75. The MCMJ also provides the possibility of correctional custody for no more than 7 days when imposed by a company grade officer in command, and for no more than 30 days when imposed by a field grade officer in command. Despite having this authority under the MCMJ, it is extremely rare for commanders to impose correctional custody as part of the Article 5 process. If your commander attempts to have you incarcerated through use of the Article 5 process, please ask to speak with a trial defense attorney immediately. It should be noted that no commander may impose a punitive discharge in the Article 5 process. Let's look at the potential punishments at a court-martial. You will see that there are differences between a court-martial and an Article 5 proceeding. The punishments in a court-martial differ depending upon the type of the court-martial and can be summarized as follows. In a general court-martial, punishments include a fine of no more than $2,000, forfeiture of pay and allowances, a reprimand, dismissal for bad conduct or a dishonorable discharge, reduction of enlisted personnel to the lowest pay grade, confinement of no more than 6 months, or any combination of these punishments. In a special court-martial, punishments include a fine of no more than $1,000, forfeiture of pay and allowances, a reprimand, a bad conduct discharge, reduction of enlisted personnel to lowest pay grade, confinement of no more than 100 days, or any combination of these punishments. In a summary court-martial, punishments include confinement of no more than 25 days, reduction of enlisted personnel to the lowest grade, a fine of no more than $100, or any combination of these punishments. Please note that special and general courts-martial can impose a punitive separation from the military on a soldier. A punitive separation will deprive a soldier of many, if not all, of the benefits that may be given by the Army, the Veterans Administration, and any applicable provision of state law. Turning down an Article 5 and requesting a trial by courts-martial is a very serious decision. You run the risk of certain legal consequences like time in jail, which should not be undertaken without careful thought. Do not turn down an Article 5 without first speaking with a lawyer from Trial Defense Services. Please take a moment and review the personnel identification information on your copy of the Article 5 form. Ensure that your name, pay grade, Social Security number, unit, and pay are correct on all pages of the form. You must also read and understand the charges against you. If you do not understand the nature of the charges, please ask to speak with an attorney with the Trial Defense Service. This lawyer will help you understand what allegations you are facing and the best way to address those allegations. Block 11 on the form AGO 202, which corresponds with Block 3 A and B on the DA Form 2627, is an important block on the form. You can either turn down the Article 5 you have been offered and request a trial by courts-martial, or accept the proceedings under Article 5. Do not turn down an Article 5 without speaking with an attorney first. If you elect to proceed with the Article 5, then you will have a series of choices to make. First, look in Block 12 of the AGO 202. I desire to make an oral presentation before you, or I do not desire to make an oral presentation before you. This corresponds to Block 3B, 2 and 3 on the DA Form 2627. You must decide what, if anything, you'll say to the commander imposing the Article 5. If you did not commit these crimes, then you should submit matters in defense. An explanation that simply disclaims responsibility usually will not help much, so you should determine what witnesses or other evidence is necessary to help prove your innocence. If using the form AGO 202, Block 13, which is similar to Block 3B3 of the DA Form 2627, it asks, what, if any, matters will you present to the commander imposing this Article 5? Matters of defense, mitigation, or extenuation may be witnesses or some tangible evidence like documents. If you have nothing to present, then check the box, I do not desire to make a written presentation block. If you have a written presentation, then you should check, I have attached my written presentation block. If you want to provide a written presentation at this time, you should check the My Written Presentation Follows block and provide your written presentation on the additional page if necessary. Finally, look at AGO Form 202A, which corresponds to Block 4C and Block 5 on the DA Form 2627. Will you want to appeal this Article 5 once it is complete? You can appeal the imposing commander's conclusion that you committed the offense alleged, as well as the nature of the punishment imposed. The commander who will act on your appeal will consider all documents that you submitted to the imposing commander. If you want the commander acting on the appeal to consider anything else, you must submit those matters to the commander acting on the appeal. Please note, the commander acting on the appeal cannot make the punishment worse. If you do not want an appeal, then check the I do not appeal block. If you want to appeal and submit additional matters, then check the I do appeal and submit the following matters in defense, extenuation, or mitigation block. Please note that you have only one appeal in the Article 5 process, and your appeal should be filed within 5 calendar days, not duty days. Any appeal filed after 5 days can be denied just because it was filed late, unless the superior commander determines that there is a good reason for the late filing. The last decision that the imposing commander must make is how this record of non-judicial punishment will be recorded. If the soldier receiving an Article 5 is a specialist or below, the record will be automatically filed locally. If the soldier receiving an Article 5 is a sergeant or above, it will be filed in either the restricted or performance fiche of the recipient's official military personnel file. The filing decision will be made by your commander at the end of the Article 5 hearing. Always remember that accepting an Article 5 is merely the acceptance of a procedure, not an acknowledgement of guilt. The imposing commander must be convinced beyond a reasonable doubt that you are guilty of the offenses listed. Remember that in the military you can assert what is commonly referred to as the good soldier defense. A good soldier defense is a complete defense that rests on the logic that good soldiers do not commit crimes. You are a good soldier and therefore you did not commit this crime. You will prove you are a good soldier with testimony from witnesses that work on a regular basis, as well as any documents you might have that will lead to the same conclusion. If you committed these crimes, then what would you say about the offenses that would lead your commander to reduce the punishment he gives you? These are things that would help explain your action in a more positive light. For instance, a soldier offered an Article 5 for assault consummated by battery on another soldier might point out the facts that caused the altercation. If you accept responsibility for what happened, then what would you tell your commander about yourself to reduce any punishment that he would give you? Are you suffering from financial hardship? Will any reduction or forfeiture eliminate your ability to help a family member in need? You will be offered the opportunity to contact and speak with a lawyer from the Trial Defense Service after this video is completed. Your communication with the trial defense attorney may have to occur during the time period between drills, but can be as short a period as 48 hours if your duty period allows it. Please take that opportunity if you have any questions as to what you should say, and present during your Article 5 hearing. You are only entitled to as little as 48 duty hours to seek legal counsel. If you do not feel that you need to speak to a trial defense attorney and want to proceed with your hearing in less than 48 hours, then you will have to sign a waiver acknowledging that you have been provided the opportunity to speak with a trial defense attorney and that you choose not to exercise that right and requested to proceed with the hearing without the 48-hour delay. We hope that this information has assisted you in understanding the Article 5 process. Please do not hesitate to request an opportunity to speak with a trial defense attorney if you feel that you should. Thank you.